Good morning, good afternoon, and good evening to everyone around the world. My name is Omar Hernandez. I'm a Public Information Officer and Program Manager at the United Nations Academic Impact in New York. It is a real pleasure to be here with all of you from the United Nations headquarters in New York in this new edition of the UNAI SDGs workshops intended to foster advocacy and awareness as well as outreach about the 2030 Agenda for Sustainable Development and the critical role of institutions of higher education regarding the fulfillment of all 17 SDGs. And today, we're very privileged to have a panel composed of experts and, of course, the presence of the President of the International Criminal Court to specifically target Goal 16. And with that, I will now give the floor to Mr. Robert Skinner, who is the Deputy Director of the Outreach Division. Rob, you have the floor. Thank you.
Thank you very much, Omar. And I would also like to say good morning, good afternoon, and good evening to everyone. I'd like to first thank the panel for joining us. In particular, I'd like to thank Judge Hofmansky, the President of the International Criminal Court, and his team at the ICC, who have really helped spur this conversation and help us put this session together. International Justice and Goal 16 beyond the targets. And we have an amazing panel who I won't mention them all now because they'll all be introduced as we go forward. But I'm just, again, I personally am really excited about this conversation. Way back several careers ago, I guess, I was a criminal defense attorney. And so this conversation around international justice is very exciting. And I'm enthusiastic about hearing from all of the distinguished panelists that are joining us. So welcome to all of the panelists. Welcome to all of you that are joining us from around the world. We always appreciate that we get such amazing attendance from really all corners of the globe at all hours of the day and night, wherever you are. So great appreciation to all of you as well. And with that, I will turn it to Jayashri Wyatt, the Chief of the Education Outreach Section, to talk a little bit about UN academic impact and where we're headed with that before we get underway with this really amazing session.
Thank you so much, Rob. Good morning, good afternoon, good evening. Jayashri Wyatt, the Chief of the Education Outreach Section. Which oversees the United Nations Impact, which sits in the Outreach Division at the Department of Global Communications in the UN Secretariat here in New York. And the UN Academic Initiative is a network of more than 1,500 institutions of higher learning across the globe. And our primary role here in the Secretariat in the UN is to convene esteemed scholars, researchers, and practitioners to engage really with each other, to share knowledge, best practices, lessons learned, and to actively promote and contribute to the realization of the values and principles of the United Nations. And I suspect that today, many of those who are joining us and the panelists themselves, we dream of a world that is liberated from injustice, mendacity, atrocity, crimes against humanity, a world where all people can live in peace, dignity, and equality on a healthy planet, a world where all people can enjoy and exercise their full human rights. And we know, of course, that this world does not yet exist. There are many, many challenges to this world that we are trying to create together. And as the United Nations Academic Impact, we hold the space today for this very significant conversation and this discourse on international justice. And like Rob, I just would like to say how thrilled we are to have such an esteemed group of scholars and practitioners. And I wish you all an excellent conversation today, and we'll be here to learn from you, from your expertise. Thank you very much indeed. Over.
Thank you to Yashri and Rob for their remarks. And now it is my privilege to introduce to you the keynote speaker of today's session. We have with us today His Honor Judge Pierre Hofmansky.
You muted, Omar.
I'm sorry. We have the honor to have with us His Honor Judge Pierre Hofmansky, who, in addition to being the president of the International Criminal Court, which is why he's going to be delivering the keynote speech today, he's also have an academic background, so he's also a professor. So, which is something that we really value as the UN Academic Impact, which precisely is this initiative in the Outreach Division of the UN Department of Global Communications that liaises with universities and colleges around the world. And with that, I will now give the floor to His Honor, Judge Pierre Hofmansky. You have the floor, sir. Thank you very much. I believe we have some technical issues with the president of the ICC.
It appears that the mic is muted.
Yes. I don't know, Your Honor, if your team can. Yes. Now
Yes.
it's on mute. Yes.
Thank you, Mr. Chair. Dear professors, students, ladies and gentlemen, I'd like to begin by thanking the United Nations Academic Impact for co-hosting this workshop with the International Criminal Court. And I want to thank all of those who have joined us. It is really wonderful to see so many people interested in this important topic. While the UN and the International Criminal Court are separate organizations, we have a very close relationship and excellent cooperation. The shared values of peace, security, the rule of law, and the respect for human rights guide both our work and the fulfillment of the UN's Sustainable Development Goals. Today, I would like to discuss how the work of the International Criminal Court is integral to Sustainable Development Goal 16 on peace, justice, and strong institutions. The ICC helps build a more peaceful world by deterring violent crimes through the rule of law, strong institutions, and access to justice. For those who may not be familiar, the International Criminal Court is a permanent, independent international court. The Rome Statute, the ICC's founding treaty, was adopted in July 1998 and entered into force on 1st July 2002, which made the ICC operational. So the court is 20 years old this year. Today, 123 countries are state parties to the Rome Statute, representing all regions. The international community came together to create the ICC in order to put an end to impunity for the most atrocious crimes under international law, genocide, crimes against humanity, war crimes, and the crime of aggression. The ICC's central mission is to ensure accountability and justice for these crimes, and by doing so, help their prevention. The ICC is a criminal court. Therefore, it prosecutes individuals, not groups or states. There are no immunities under the ICC statute. Anyone could be held responsible, regardless of their rank or position. And important tenet of the Rome Statute is the so-called principle of complementarity. This means that it is, in the first place, every state's duty to exercise their own criminal jurisdiction over those responsible for international crimes. The ICC intervenes only when states are not doing that for any reason, whether for lack of ability or willingness. This is to say the ICC is not intended to replace national courts. Instead, it is a court of the last resort. Today, the ICC is busier than ever before. We currently have 70 investigations open across multiple continents and a record number of 5 cases on trial, with more in the pipeline. Sadly, there is huge demand for the ICC's mandate as many conflicts and heinous crimes continue in different parts of the world. Now, getting back to SDG 16, goal and the specific targets that are part of it. In my remarks, I will focus on 3 ways the ICC helps the implementation of SDG 16. Number 1 is reducing all forms of violence. This is target 16.1. Number 2 is promoting the rule of law and ensuring equal access to justice. It is target 16.3. And number 3, strengthening national institutions, with this target 16A. So let me begin with target 61, reducing violence. As I said, this is one of the goals behind the creation of the ICC, and it is reflected in the preamble of the Rome Statute. This is, of course, in line with the general purpose of criminal justice system, which all seek to deter criminal acts by creating a credible risk of accountability and punishment for the offenders. It is not the only purpose of criminal justice, but it is one of them. As such, the ICC system inherently works to reduce violence. I am not claiming that the ICC will eradicate armed conflicts or crimes against humanity from the planet. Just like murders and death still exist despite the police and courts. But compared to some of its predecessors, such as the tribunals for Rwanda, Cambodia, or Sierra Leone, the great thing about the ICC is that it is a forward-looking institution and not just created after the fact. It has the potential to put future perpetrators on notice that they could be held responsible for their actions. And indeed, there is a growing body of academic research that points the deterrent effect of the International Criminal Court. Let me reference a few such studies. Professor Gov Dance's research has indicated that the states that ratified the Rome Statute during the course of a conflict were more likely to end that conflict through negotiation than other states. He also looked at the rate at which new conflicts began in the ICC state parties versus non-members, including that ICC state parties were significantly less likely to become involved in the new conflicts than non-state parties. Professor Courtney Hillebrand explored the effect of the ICC's involvement in Libya on civilian deaths. Her findings suggested that while the ICC's involvement did not stop the violence against civilians, it did correlate with a statistically significant reduction of the violence. Professor Helen Joe and Beth Simpsons have conducted research into the ICC's effect of violence against civilians across a wide range of countries and covering a period of more than 20 years. Based on a statistical analysis, they estimated that Rome Statute ratification reduces the rate of government-sponsored killings by nearly 50%. Professor James Merring looked at the effect of ratification of the Rome Statute on state behavior, concluding that the states that demonstrated commitment to the ICC also had higher level of human rights protection, fewer human rights abuses, and fewer instances of internal violence. Professor Benjamin Peel's research indicated that the human rights records of states that ratified the Rome Statute were not only better and average than those of non-ratifiers, but they also continued to improve after ratification more than the human rights records of non-ratifiers. In these words, the study represents systematic evidence that the court can deter leaders from committing atrocities. Of course, the ICC is not a magic wand. However, these studies clearly point to growing evidence that the ICC has a real impact that reduces violence in the long term. The second target I'd like to discuss is number 16.3, promoting the rule of law and ensuring equal access to justice. At its core, the ICC is an avenue for justice when other avenues do not exist or they are blocked. While the ICC is a court of last resort, it can and has stepped in when states are unwilling or unable to conduct the necessary national proceedings. At the ICC, victims have a very strong position compared to earlier international tribunals. Victims have the right to be represented by a lawyer in the court, to express their views, and to request reparation for the harm they have suffered. Access to justice starts with knowledge of one's right and of the justice system. The ICC engage directly with the victims and communities affected by crimes through its outreach program. Our staff reach out to people in local languages, traveling to the smallest villages in the affected communities to inform victims about their right to participate in the proceedings and apply for reparations. The ICC also has a trust fund for victims, which delivers assistance and reparation to victims to help survivors to rebuild their lives. These measures include physical and psychological rehabilitation as well as socioeconomic support. To date, hundreds of thousands of victims and family members have benefited from these programs. These features represent an important step forward in the development of international criminal justice and the reach of access to justice. The ICC is also inherently promotes the rule of law. In the words of Ben Ferenc, the last surviving prosecutor of the Nuremberg trials, one must replace the law of force with the force of law, for the rule of law to be applied meaningfully. Independent and impartial courts as absolutely crucial. These principles are at the core of the ICC. International law has often been dismissed on being abstract and not readily enforceable. Consider the Geneva Conventions, which establish international legal standards for humanitarian treatment during times of war. Yet, while the conventions entered in force over 70 years ago, for a long time there was no international legal mechanism for holding transgressors of those rules accountable. Today, the ICC is actively addressing these and other crimes. Since it was established 20 years ago, 31 cases involving 51 suspects or accused have been brought before the ICC. Specific cases have addressed crimes including the use of child soldiers, rape as a tool of war, attacks on civilians, forcible displacement, destruction of cultural heritage, attacks on peacekeepers, murder, and more. As an impartial court, the ICC has also acquitted the accused person, and the guilt was not proven beyond reasonable doubts. Finally, regarding Target 16A, the ICC system helps to strengthen relevant national institutions. The ICC is a catalyst for national capacity building. To date, many dozens of states have improved and enhanced their own criminal legislation to incorporate crimes under the Rome Statute. Let me remind again that the ICC is not court of last resort that steps only in the absence of genuine national proceedings. Most states would rather avoid that. So being part of the system creates an incentive for them to step up their own capacity to investigate and prosecute atrocity crimes. Where necessary, support for the capacity building at the national level is available through the Assembly of State Parties to the Rome Statute. Also, the ICC itself is always ready to share expertise if asked to do so. Mr. Chair, dear professors, students, ladies, gentlemen, I will stop here to give time for the upcoming discussions. I look forward to listening to the interventions from the estimated group of panelists, and I also am available to take later questions you may have for me. Thank you. Thank you very much.
Thank you very much indeed, Your Honor, for your participation as a keynote speaker in our event today. Certainly, you set the tone for our discussion this morning here in New York. And with that, I will now go to the panelists, the esteemed experts that we have invited and greatly accepted our invitation. The first one is going to be Professor Rebecca Hamilton. She's a professor of law at the American University here at the United States, formerly served in the Office of the Prosecutor of the International Criminal Court in The Hague. She's the author of numerous publications, including the book Fighting for Darfur, Public Action and the Struggle to Stop Genocide, and she's also a member of the Council on Foreign Relations. Professor Hamilton, you have the floor. Thank you very much.
Thank you so much. It's such a pleasure to be here with this wonderful gathering, and especially to hear from the President of the ICC. Thank you for your remarks. As I think everyone would have understood from what you said, the promise of the ICC is so much more than simply the prospect of a criminal trial. In fact, what happens in the courtroom, while hugely visible, is just one small piece of the ICC's contribution to the rule of law. Equally important, in my view, is the work that it is doing in capturing the public imagination, catalyzing that desire for accountability. And we see this around the world, and in particular in Ukraine right now. The work of citizens themselves doing digital documentation in the quest for accountability, and the work that the ICC can and is doing in supporting domestic jurisdictions, prosecutors in domestic jurisdictions who are going after serious international crimes. Yet even in doing all this, I think it's important to remember that justice itself is so much more than just criminal accountability. And as we head towards 2030, I would call on all of us involved in this sphere of international justice to really double down on our efforts to listen to the survivors of atrocities and put their goals at the front and center of our efforts, even and especially perhaps when they place reparations, reconstruction, health and education, direct personal acknowledgement of wrongdoing, or other goals ahead of the kind of justice that happens in a criminal trial. As everyone on this call knows, SDG 16 provides space also for us to consider the contribution of academia to a more equitable and just world. And so in that regard, I wanted to take a moment to highlight two of the features of what we do at American University, Washington College of Law. The first is our clinical work, those law professors that don't just teach future generations of lawyers in the classrooms, but who get them working on cases representing those who don't otherwise have access to representation. So if we think of SDG 16.3, promoting the rule of law at national and international levels to ensure equal justice for all, part of what our faculty and students do every day supports this goal. To take one example, faculty and students from our War Crimes Research Office and our Human Rights Academy worked on the Saparzako case, this groundbreaking prosecution that has become a case study in survivor-centered justice and which provided redress for Indigenous victims of sexual violence and sexual slavery during Guatemala's civil war. Closer to home, the work of our Human Rights Clinic in representing Afghan refugees here in the Washington, D.C. area who have been left without representation following the US withdrawal from Afghanistan. The second aspect of what we do here that I wanted to highlight is the convening role that academia can play by bringing the world into our classrooms. If we think of goal 16.A, strengthening the capacity of national institutions and in particular developing countries to prevent violence, combat terrorism and crime. Just yesterday, I met with the Hubert Humphrey Fellows that American University is hosting this year. They are judges, lawyers, police officers, activists from the Philippines, from Ethiopia, from Belarus, and they are all gathering to learn with and from each other in a safe academic setting. They'll return to their home countries with new ideas, connections, and a renewed commitment to the work that they are already doing to strengthen those domestic institutions. So in sum, I would say that we know there is no single pathway to achieving the world that we strive for, but if we can each work in our own spheres, whether that is in practice or in academia, to stand in solidarity with those who are seeking justice, then we will and we are making progress. Thank you.
Thank you very much, Professor Hamilton, for your remarks and also for highlighting one of the best practices of a few of the best practices of American University, which also happens to be one of the member institutions of UNAI. And also, of course, we remember the words of Judge Hofmansky when he actually presented a lot of academic research references. So this is clearly an example, both your words and that of your honor, that this connection between academia and the practice of law, particularly when it comes to international justice. And with that, I will now give the floor to Dr. Bertrand Ramcharan. He's the former chancellor of the University of Guyana in Guyana, and he also was he was an adjunct professor at Columbia University in the United States, perhaps he's more known as a former deputy and acting United Nations High Commissioner for Human Rights. And he has authored a number of books, including Conflict Prevention in the UN's Agenda 2030, Development, Peace, Justice, and Human Rights. And with that, I would like to give the floor to Dr. Bertrand Ramcharan. Sir, you have the floor.
Thank you very much for having me on this panel. Professor Hofmansky, let me say that I listened to your address with great respect. And I will have a few comments a bit further on. And of course, I listened to the heart and the passion of Professor Hamilton, and I have much respect for that as well. I'd like to speak rather openly to you. Professor Hofmansky, in your foreword to the book put out by the Nuremberg Academy on the 20th anniversary of the ICC, you raised the issue of whether or not national jurisdictions will actually be ready to take on prosecutions of criminal activities. And elsewhere in the book, there is a kind of a question mark as to whether or not this principle of complementarity will actually be achieved anytime soon. That's the first point I want to note. Then I want to note, if I may, that if we look around us, the SDG report this year, which was sent to me by Omar, it tells us that the world witnessed the largest number of violent conflicts since 1946, with 1/4 of the global population living in conflict-affected countries at the end of 2020. And then they're referring to the number of civilian conflict-related deaths, although it dropped by 17%, is still very large. Then I want to say this, if I may. In the world around us, we are seeing a challenge to global values. We are seeing the decline of democracy. And I want to say to you that I am in the process of putting out a global handbook on national protection systems. And in the great majority of the countries of the world, there is not evidence that there is an adequate and effective national protection system. When Secretary General Annan was the Secretary General and he came up with his reform agenda, I was the one who wrote the well-known Action 2. Action 2 called upon the institutions of the United Nations system to work together with countries for the enhancement of their national protection systems. And we defined the national protection system as having 6 components. Is the constitution of a country reflective of fundamental norms of international law? Likewise, does its legislation reflect human rights treaties? Are its courts able to apply international human rights norms? Does it have a national human rights commission? Does it teach human rights? And does it have preventive measures within the country? So now, why am I saying this? I'm saying this because I have profound faith in the mission of the International Criminal Court. When the first prosecutor of the court was appointed, he came to Geneva to see me. I was then the acting High Commissioner for Human Rights, and I pledged the support of the Office of the High Commissioner to him. So I am, in spirit and in philosophy, supportive of the mission of the court. And I like very much what you said, Professor Hofmansky: reducing violence, promoting the rule of law, strengthening of national institutions. But I want to say in all candor, I do not see this evidence of the strengthening of national human rights institutions. And so the contribution that I would like to make today is to ask you and to ask the panelists and to ask the audience to focus in more and more on the absence of national human rights protection systems within the great majority of countries. There is much more that I could say, but I think I will end with this one point. And let me just say this one. I was present some while back when Governor Scranton was the ambassador of the United Nations. This was in 1977. And he came to the United Nations and he delivered a speech to the General Assembly with the title, "Human Rights, Let Us Mean What We Say." Well, I'm very sorry to have to say to you that in the world, many countries do not mean what they say. And let me just make this final point. I have served in the Office of the Secretary General as speechwriting service. I was in the Yugoslav peace negotiations for 3.5 years. I was a director in the political department for 3 years, and I served for many years in the human rights area. And now something that is very important in all of these endeavors, vis-a-vis human rights, vis-a-vis the International Criminal Court, confidence building and political strategies have to go in tandem with legal strategies. And so I just throw that thought, I end with these two thoughts. National protection systems are important, and legal strategies have to be accompanied by political and confidence building strategies. Thank you very much for allowing me to join you. Thank you. Goodbye.
Thank you very much, Dr. Bertrand, for your passionate remarks, and indeed for reminding us of the things that we still need to achieve to have a world in which justice prevails against all the challenges that we are facing. And just as a response to some people's comments on the chat box, indeed, this session is being recorded and the video will be uploaded to our YouTube channel, and the link will be shared along with the slides that were presented by the President of the International Criminal Court. And this will happen as soon as the video is uploaded to the YouTube channel. We will send a blast email to all those who register for this event. And with that, and now I would like to give the floor to Dr. Mihir Kanade. He's the academic coordinator, head of the Department of International Law, and director of the Human Rights Center at the University for Peace in Costa Rica, who also happens to be the SDG hub for Goal 12 of UNAI. He's the author of a number of books, including the Multilateral Trade System and Human Rights. And he's also the chair of the United Nations Human Rights Council Expert Mechanism on the Right to Development. Dr. Mihir, you have the floor. Thank you very much.
Thank you very much, Mr. Omar Fernandez and your team at the United Nations Academic Impact for inviting me to this panel discussion on this very important topic of international justice and the SDGs. And thank you also to the International Criminal Court for co-hosting this important panel. Now, it's a particular pleasure for me to be part of this panel since I represent a university which is named the University for Peace. I have been asked to share not just my thoughts on this topic, but also the things that we do at the university to contribute to access to justice. And so I think it would be apt if I speak a bit about the university to situate our role in this context. Now, the University for Peace is part of the academic wing of the United Nations. As you can see from my backdrop, it's mandated to award master's and doctoral degrees in fields converging around the theme of peace building. The university is a very unique institution because not only is it a university, it's also an international treaty body with its own membership with states as its parties. The UN General Assembly resolution adopting the UPeace Treaty recognizes very clearly that the mission of the university is to act as an institution of higher learning for humanity, to disseminate, learn about peace through education. And so it's not surprising that SDG 16 and within it access to justice has been at the heart of our activities since the adoption of the 2030 agenda. Now, it's quite clear that the objective of realizing peaceful and inclusive societies requires the mainstreaming of a culture of peace. This week, the United Nations General Assembly is hosting a panel, a high-level panel on culture of peace, and therefore this particular panel today is also an opportune moment to talk a bit about that. Developing a culture of peace is not something that can simply be manufactured through a written governmental or intergovernmental policy. It needs accountable institutions which support the development of a culture of peace. And this is where access to justice becomes quite central. As an international human rights lawyer working in a peace university for 14 years now, it's become very clear to me and to all of us at the university that there is no peace without justice, despite ongoing discussions around the world on the veracity of this particular theme. If victims of violations do not have access to justice, conflicts will resurface. And this has been our experience working in on the ground in places like Somalia, Somaliland, Uganda, Ethiopia and Eritrea, Honduras, Sri Lanka, Colombia, amongst others. Now, it is in this context that I would like to piggyback or draw on SDG 16.A that was referred to by Judge Hofmansky in his presentation. As some of you might be aware, the 2030 agenda outlines separately about 62 targets as they're called means of implementation targets. Out of the 169, there are 62 that are separately outlined or articulated as the means of implementation targets, which means that unless these 62 means of implementation targets are themselves realized, it is impossible to realize the other 169 goals, targets. Where do we find these means of implementation targets? SDG 17 is the means of implementing all the preceding 16 goals. But in each of the preceding 16 goals, you would notice upon close inspection that there are numerical targets, for instance, 16.1, 16.2, 16.3, etc., followed by alphabetical targets, 16.A, 16.B, etc. And these alphabetical targets are the means of realizing the numerical targets in that particular goal. Now, a lot has been said also by Mr. Ramcharan on the importance of strengthening national institutions. And that precisely is what SDG 16.8 talks about. Strengthen relevant national institutions, including through international cooperation for building capacity at all levels, in particular in developing countries, to prevent violence and combat terrorism and crime. Unless this target is realized, it is not possible to realize the preceding numerical targets under SDG 16. But this is not a task only of the ICC or the international organizations or states. This is also a contribution that academic institutions can make. So I'd like to give three or four examples of what the University for Peace has been doing in order to contribute towards strengthening national capacities and institutions. This requires being innovative. So the first project I can talk about is a project which we have been conducting in Honduras with the support of the Office of the High Commissioner for Human Rights, which trains judges, prosecutors, lawyers, and human rights defenders in a very unique format of a master's degree program on international law and access to justice. So it is a hybrid program which looks at both online component and on-site components. Judges, prosecutors, lawyers, human rights defenders can complete a module and get a certificate. They can proceed to the next module and get a diploma, and they can then proceed to the next module, a final module with a research project, and get a master's degree. And this has been extremely successful, and although it's a pilot project, we are convinced that this is a model that can be replicated in other parts of the world. In Uganda, we have a master's degree on governance and peace, which is specifically aimed at the police officers in Uganda. As we know, there is a lot of need and necessity for training of police officers, particularly to facilitate access to justice. And so this innovative program focuses specifically on police officers. I also co-coordinate an LLM program in transnational crime and justice, which UPeace offers jointly with the United Nations Interregional Criminal Research Institute, or UNICRI, in Turin in Italy. And part of what we do in that program is consciously try to focus on selecting judges and prosecutors as participants. And we designed it in a way that the on-campus component is only 6 months, so that the participants can actually leave their jobs, take a leave, and come and join the program. And instead of writing a thesis as a final graduation project, we require them to invest in an actual investigation and conduct, which ultimately leads to a mega moot court competition where judges from the ICC are also invited. Apart from this, we have done a lot of research with GIZ publications on access to justice, also conducted a lot of activities on the margins of the General Assembly and the UN Human Rights Council, with side events on access to justice. And this is all to point out that academic institutions can indeed contribute collectively to strengthening national capacities. It's not only a role that can be played by states or international organizations. I'll stop there with my statement. Thank you very much.
Thank you very much indeed, Dr. Rami, here for your words and for, again, reminding us about the critical relevance of academic institutions. And thank you for pointing out all the wonderful efforts that the UPC is doing, not only in terms of teaching, but also in terms of training, especially these core groups of people that indeed need to be trained on human rights and how better to protect them. So thank you very much again for that. With that, I'll now give the floor to Dr. Hélène Tigrugia. She's a visiting scholar at New York University in the United States. She's also a law professor at Aix Marseille University in France. She's the co-author of the book Traité des droits international des droits de l'homme, and she's an expert on reparations before the International Criminal Court. And she's also a member of the United Nations Human Rights Committee that oversees the implementation of the International Covenant on Civil and Political Rights. Dr. Hélène, you have the floor. Thank you very much.
Thank you. Thank you very much for this invitation to take the floor in this panel, and thanks for to the UN Academic Impact and also the ICC to give the floor to academics, because in general we have academic conference on justice and so on, but it's not that frequent, I would say, to have this space of reflection about how academic and how higher education may play a role and make the difference when we talk about access to justice. As you said, I have the honor to serve in two universities, NYU and Aix-Marseille University. So I will share some of my experience in terms of teaching, and especially in terms of teaching international criminal law in relation with international humanitarian law and international human rights law. With a specific example, I have focused here at NYU my international criminal law seminar on sexual violence. And what I try to do is with the students is to explain, and I will give you a very brief overview, but to explain the way sexual violence is used not only during armed conflict, but also during military occupation and during post-conflict situation. And the interest for me when we talk about international justice and when we talk about this type of crime, sexual violence during armed conflict, is not only to analyze the role of the ICC in fighting against sexual violence and the use of sexual violence during armed conflict, but also to address the way other international institutions may play a role when we talk about sexual violence. For instance, we discuss about the practice of the African Commission on Human and People's Rights, and especially some important decisions concerning the use of sexual violence in Democratic Republic of Congo, for instance, or the practice of inter-American organs, the Inter-American Commission on Human Rights, the Inter-American Court of Human Rights, especially when dealing with the use of sexual violence in different countries like Colombia, like Mexico. And also you said I'm a member of the Human Rights Committee. So indeed, I also try to explain how the jurisprudence and the practice of the Human Rights Committee in relation with sexual violence in context of armed conflict, domestic armed conflict, international armed conflict, or internal armed conflict, for instance, again, in DRC, Democratic Republic of Congo, or in other countries like Nepal. And the interest of gathering all these materials is precisely to illustrate that when we talk about such a dramatic crime as sexual violence. It's not only about ICC to address this crime, but it's really, as other panelists have already said, it's really a combination of different institutions, not so international criminal institution, but also human rights organs. And we also work on how domestic tribunals, domestic organs may and should address, based on principle of complementarity, for instance, should address this international crime and sexual violence in particular. And the purpose of the seminar, especially in relation to SDG 16, is precisely of, I would say, 2 or 3 elements. First, and when we talk about international justice, it's extremely important. First, to make more visible the pattern of inequality, the pattern of structural discrimination that are the roots of international crimes in general, but sexual violence and sexual-based violence in particular. So the interest also is to make students more aware of the fact that when we talk about sexual violence during an armed conflict, it's really based on a pattern of discrimination that already exists in peacetime. For instance, discrimination against women, discrimination against people living in poverty, discrimination against elderly person, against person with disabilities, against LGBT person, and so on and so forth. So when we talk about international crimes, it's and that's the interest of this seminar at NYU and in France. It's not just sometimes that happen in emergency situation, but in general, these crimes are rooted in situation of inequality. So it's extremely important to understand this continuum of discrimination, violation of human rights. And I fully agree to what was said before. We cannot do anything at the international level in terms of international justice if we do not have very strong human rights domestic institutions. So it's really important to understand this. When there is a rape during an armed conflict, it happens because at the very beginning, during a peacetime, there is a huge problem of inequality. There is a huge problem of structural discrimination. And of course, states have to address this situation. The other element, and I will be very brief, of the seminar and the interest of the seminar is also to make more visible the means precisely to prevent these grave and massive violation of human rights, dignity, and what it means to fight against impunity in terms of, as we have said, role of international justice, not only criminal justice, human rights organs, but also the role of domestic tribunal based on universal jurisdiction, for instance, and different forms of combination of responsibility and form of accountability. And that's my final point. The role of students and the role of academics in this area is precisely, for instance, in terms of legal clinics. So at NYU and also in France, we have different legal clinics that may, for instance, directly intervene in international proceedings representing victims, but also developing third-party interventions. So the interest of the seminar is also to show, not from only a theoretical point of view, but very concretely how academic and students can make the difference when we talk about access to justice. Thank you very much.
Merci beaucoup, Professor Hélène. And this is very important to make the teaching that is done in universities when it comes to these kind of issues as practical as possible and less theoretical, so students can actually see the actual implementation of whatever is being taught by experts like yourself. So thank you very much for highlighting that and the work that you have been doing both in academia and elsewhere. Last but not least, I would like to present now Dr. Conrad Nyamutata. He's a senior lecturer in law and member of the Center for Law, Justice and Society at the Montfort University in the United Kingdom, which is also the SDG hub of the UN Academic Impact for Goal 16, which is the focus of our webinar today. He's also the sub-editor of the European Criminal Law Review, and he's the co-author of the book Rewriting Children's Rights Judgments from an Academic Vision to New Practice. And before I give you the floor, sir, just to echo the words of Professor Alain in terms of these interconnections between the SDGs. Although we are focusing today in SDGs, in SDG 16 particularly, of course, when it comes to inequalities and discrimination and poverty, this is all interrelated. So we cannot speak about different silos of SDGs because that's why we have the agenda as a whole to guide us through, but also to acknowledge the fact that we have over 240 attendees in this event from all around the world, as I can see from the chat box, so we're very pleased because of that. Dr. Conrad, without further ado, you have the floor. Thank you very much.
Oh, thank you very much, Omar, and thank you very much to your organization, the president of the ICC, and those eminent speakers that have spoken before me, who clearly have a lot of experience with regards to peace, justice, and strong institutions. Now, as you rightly said, we are the hub of SDG Goal 16 in the United Kingdom, and we have tried as much as we can to mainstream SDG Goal 16 across all faculties. Now, I wanted to focus my remarks on one area that is close to my heart, and I think which is very critical in our aspirations to achieve peace, justice, and strong institutions, and that is children and young people. I'm sure you'll agree that if we are going to achieve sustainable peace and reduce forms of violence and create strong institutions, we have to focus on children and young people. Children suffer most, as we know, as a result of conflict, disasters, and also poor governance. I want to look at this in two ways. And then since most of us here are academics, to ask how academia can contribute to peace, justice, and strong institutions in line with what Helena and others have actually said, with children in mind. And secondly, again, as academics, how do we train young people, in our case, lawyers, to pursue these goals? Part of my research is focused on what we commonly know as child soldiers, who have already been referred to by the president of the ICC. The figures are quite frightening. If these are accurate, 250,000 children fighting in wars all over the world, recruited by force or by false promises of an escape from poverty. Now, there are obviously debates around how we treat children. The issue of justice with regards to child soldiers is very complex and very controversial. I think we saw this at the establishment of the Special Court for Sierra Leone, with the central question to prosecute or to rehabilitate. Children can be both perpetrators and victims. As we saw in the case of the Sierra Leone situation, the prosecutor there, David Crane, decided not to prosecute children. And I think this was the correct approach. And this was partly because of the pressure which was put by civil society organizations. So it is important that we recognize the role that civil society organizations can play in achieving peace, justice, and strong institutions. Of course, this debate is not as simplistic as I put it. There is scholarship which is emerging right now that child soldiers should not be treated as faultless passive victims. In my view, I think the victim-first approach should be the guiding principle when we treat children who have been socialized in environments of brutality. Now, the ICC does not prosecute, obviously, children under the age of 18. However, the prosecution of Lubanga, Ntaganda, and recently Ongwen highlighted the magnitude of the problems and the horrors that children who are recruited by non-state armed groups, and we know that states also recruit child soldiers since the Machel report of 1996. Now, as academia, as Helen and others have also mentioned, we can contribute ideas to building peace, justice, and strong institutions. On our part, a few years ago, we came together under a project which was known as rewriting children's rights judgments from academic vision to new practices, Omar said. The aim was to eliminate the conceptual and practical challenges of securing children's rights within judicial decision-making and explore how developments in theory and practice can inform and reinvigorate the legal protection of children's rights. Myself and another colleague, we focused on the judgment on Thomas Lubanga and looking at how it actually integrates the idea of human rights, in particular the United Nations Convention on the Rights of the Child. And I've just noticed today that there's also a publication which has followed the same pattern, I think published just a few weeks ago, entitled Feminist Judgments at the International Criminal Court, the case of Dominique Ongwen. In this case, I think trying to introduce feminist scholarship and women's rights. Now, the introduction of the Trust Fund for Victims, as the president of the ICC said, is a fantastic inclusion to our international justice processes. Victim participation as well, and the outreach work that the court is performing are all these commendable endeavors. And one point I would like to make in concluding about child soldiers is that if we are to achieve peace, post-conflict, I think peace processes must involve children, particularly where children have been involved in conflict. Not just to focus on rehabilitation, but to purposely engage them in order to identify structural problems which contribute to child soldiering and how children can actually contribute to peace. On the second element, which I referred to earlier on, is training. Helen was also talking about programs that they carry out. Now, we at DMU have got a vibrant school, which, like other departments, has embedded Goal 16. Our lecturers are asked to perform, to pledge to align their teaching with Goal 16, and this has been well received across the university. We attract a range of diverse students, some of whom come from conflict zones or have lived near conflict areas. We also have the Center for Law, Justice and Society with active researchers who write in leading journals. And part of my role is also to assess PhD applications. And almost always the PhD proposals we receive seek to analyze one institution or another. And through our mandatory doctoral training, our students are also encouraged to embed Goal 16. Now, we recognize that our students, the students we train are potential change agents. For those who return to their home countries in line with Goal 16.8, they can contribute to reform and international best practices and international best practice rather, and to the building of strong institutions. It is just unfortunate that sometimes the costs of higher education are so prohibitive. There are many other projects that we carry out around refugees and asylum seekers, also conduct a project on human trafficking. These are probably projects that will probably take me beyond the time that I'm allocated. So thank you very much, Omar, and thank you very much for inviting us.
Thank you very much, Dr. Conrad, for your participation. And indeed, we are pretty much aware of all the wonderful things that the Montfort University is doing as our very own hub for Goal 16. indeed, thank you for reminding about the Lubanga case, which is a landmark case of the ICC and how it connects with international human rights law, and particularly, the situation of South soldiers and the devastating consequences of armed conflict in children, which I believe sometimes is perhaps neglected in the global discourse, but certainly something that is very prevalent, and children should be the focus of our efforts. Of course, we care about all human beings, but particularly children. They're in such a vulnerable situation that indeed that case again was quite important to analyze this connection between international criminal law and international human rights law, as well as outreach and advocacy about these issues. So thank you very much for that. And with that, I would like to ask all panelists, the President of the International Criminal Court, if he's still with us, to turn on the cameras. Well, now we are going to proceed with the last part of today's session, which is the Q&A session. And we kindly ask attendees if they have any questions or comments, to write them in the chat box with your name and country or affiliation. We will do our best to liaise with the panelists and the president of the ICC to get their responses. And also I saw a comment, or more than a question, regarding the emails of the speakers. Because of privacy issues, we are not entitled to publicize the email addresses of our esteemed panelists. However, if they feel like they can themselves post that in the chat box. And with that, I would like to have the honor to pose the first question from the UNAI side. Many of our attendees are actually students, undergrad students, not only of law, but of a wide range of academic fields. So my question will be to any one of you who would like to answer or to reply to that. What role do you see to undergrad students should have to promote, and more than promote, to advance Goal 16 in practice in their different communities and countries? So I don't know who would like to answer that first. Perhaps if I can point out to Dr. Mihir, perhaps, who I know is has a very strong connection with students in the UPs. Dr. Mihir.
Yeah, thank you, Omar, for that. And as you rightly pointed out, we do have a very strong connection with students at UPs, particularly because of the sheer diversity of students that we get at the university. A typical classroom in international law and human rights program would look like 25 students from 22 countries. I mean, that's a common scene at UPs. And what happens is that many times these students' lived experiences, because they come from such diverse backgrounds, their lived experiences inform the professors rather than the other way. You can't teach humanitarian law to someone from Palestine who's being bombed every day, right? I mean, you can't teach refugee law to a person who's been a refugee for entire life. We have had students who have been child soldiers in the past. So we learn a lot from them. And I think in terms of what they can do, one of the key themes that has recurred throughout today's panelists' discussions is the lack of national capacities, right? I mean, complementarity is a principle, but the fact is that on the ground where justice ought to be served, national capacities are lacking. We can often be, in my work, I've often seen scholars or general population from the outside looking at certain countries and saying they can't get their act together. But lack of national capacities is not just because of lack of enabling internal factors. There are also factors from the outside which lead to the lack of an enabling national environment. So you need both a permissive international environment and a national environment. So the first thing that I've noticed in my work is, of course, empowering students, because youth organizations, civil society organizations comprising youth have tremendous powers to influence the fate of the country. We've seen what's happening in Sri Lanka, right? It's mostly youth-driven activities that have led to the governments being held accountable. They're students mostly. So if you're a law student, legal clinics are an excellent way, as was pointed out earlier. But if you're not, there are other ways of civil society activism of the youth. And this is where alliances with international youth organizations and student organizations help a lot. There's something called a boomerang effect, which we often use in human rights advocacy, which is, many times local student unions may not be empowered enough, may not have the capacities or the knowledge of best practices. So they throw out a boomerang, collect the similar organizations and their experiences from other parts of the world and bring them back to their countries for implementation. So I would highly encourage student organizations or students who are participating here to network with like-minded individuals from around the world, because there are always great practices, good practices, and experiences, lessons learned elsewhere from which you could borrow and draw your activities.
Thank you very much, Dr. Mihir. I don't know if another of our experts would like to jump in on this question. If not, I have a second question that was posted with one of our attendees. He or she says that if students is from a completely different field, mathematics, engineering, science, how can that student actually, go to the promotion, the active promotion of Goal 16 and human rights and justice in general? And this is a question that I used to ask the university where I used to teach in my home country, that more often than not, only students of law are the ones who actually receive some sort of training on human rights. But human rights are for all of us. So I don't know, Professor Hamilton, if you would like to jump in on that.
I would love to jump in on that, because I think what you say is absolutely true. These goals are not just for lawyers, and indeed we cannot succeed with just lawyers. So I think that it is beneficial for everybody if we really expand our sense of who are the people and the professionals and the professional areas that are contributing to these goals. If you think about what the themes that have come up in this conversation so far, when we think about national capacity, you cannot strengthen national capacity just through the work of lawyers. It requires your IT technicians, it requires your engineers, it requires everybody to make national systems work effectively. And so, I would hugely encourage someone who has a background in pure mathematics to move into this space. I think it would be a wonderful development for all of us.
Thank you very much for that. I don't know if the president of the ICC is with us. If so, we had a question just to summarize the question. Is it possible to a regular citizen to connect directly with the ICC to make a complaint about an officer, a member of the government, and so on? Is it that possible? I know the answer to that, but I would like the president of the ICC to just reply to that question.
Thank you. I hope you are able to still hear me. Well, the first, I'd like to take a position, if you allow me, to the question raised by Dr. Ramashan at the beginning of our discussion concerning the issue of the building of national capacity and strengthening the national institution. Indeed, I'm really convinced that the ICC has a very important role to play here. I am often asked by my students, how is it possible that 18 judges of the ICC deal with the crimes committed on all the continents of the world? Is it doable? The answer is very simple. It's of course not. It is of course not. It is not the role of the ICC to cover everything. And therefore, if we really would like to to fulfill the promise of the Rome Statute, we need to build the national capacity, and we need to cooperate with the national authorities and strengthen them. It is no question, and there are really. It is really the case that we do it. It is never the interest of the ICC to accumulate the jurisdiction here in The Hague. What we always try to do is by in that way that we just use the positive complementarity to convince national authorities that is their role to step in, and this is really the case. If you look what happens in Ukraine, and if you look at the activity of the prosecutor of the ICC, who is the member of the joint investigation team together with the teams for other countries, not only with Ukraine, but also with other countries in Europe. If you look the situation in Libya, where also the prosecutor is the part of the common international team to investigate crimes committed them, it means that we do everything just to activate the national jurisdiction, and also the jurisdiction base of the on the principle of the universal jurisdiction. And to achieve these goals, we need to strengthen the national capacity, and we really do a lot. And other issue that was being discussed is the role of the education, which is of course extremely important. The young people is the future of everything. It is of course the role of universities to educate, but I would like to say that the ICC also does something on this field, and we constantly organize the international moot courts with the involvement of the university, just to build awareness of the international criminal justices, of the ICC, of the role of the ICC in the world. And I think we are quite successful on this field. Well, not to take too much time, I will stop here. If there are other questions, of course, ready to stop in any time.
Thank you, Your Honor, for your remarks. I now have a question, if I may, to Dr. Bertrand Ramcharan. Actually, it's two questions. The president of the ICC said earlier in his remarks something about that some people perceive international law as being very abstract, which is something that my students of law usually told me after they came out from criminal law classes and civil law classes. So when they come to me, and my answer to most of their questions was, well, it depends. That was my question, my reply to most of their questions. And there's actually one of the attendees posed a question here, which my students more often than not did to me. How can international justice be efficient when there are no coercive forces to make the decisions mandatory? So I got that question probably at least once a week during my 16 years teaching international law. So Dr. Bertrand Ramcharan, the floor is yours.
Thank you very much. It's an important question, and I would like to answer it this way. In the work of human rights, or in the work of justice, it is important to think of what I would call the development in the society of a culture of human rights. And this, I remember when the Vienna Conference, the World Conference on Human Rights, was held in 1993, some Nobel laureates wanted to adopt a statement on the occasion. And I was asked, I was then in the Yugoslav peace negotiations, but I was asked to, when I wrote the draft, and they adopted this, and they referred to the importance of building up a culture of human rights in the society. Now, to this questioner, I would say, please keep in mind this notion of a culture of human rights within each country, within each region, and within the international community as a whole. And now the building, Ben Ferencz in the book, and Professor President Hofmanski referred to it. Ben Ferencz, in an article in this book on the 20th anniversary of the International Criminal Court, he's referring to the importance of educating people in human rights, educating people on the Universal Declaration of Human Rights, educating people in principles of justice. So I think that it is through the development of this culture of human rights, a culture of justice, that will be a supportive environment for in support of the law. Now, having said that, I was a bit, how shall I say, I was a bit candid in my remarks, and that's because I look around me and I see today on the BBC, the head of the UNDP was speaking about the 2022 Human Development Report. And he flagged the point that 9 out of 10 people in the world are going in reverse when it comes to development because of international conditions. Why do I mention this? How can we develop a culture of rights in this environment? How can we develop a culture of rights when we have a third of the population of the world affected by ongoing conflicts? And how can we develop a culture of human rights when we have such massive poverty and discrimination and sexual inequalities? So in other words, my answer to this questioner is we have to strive for a culture of rights, a culture of justice, while at the same time being mindful of the difficulties that are all around us. When I used to teach human rights at Columbia University, I used to put on the blackboard a dot. And I would say that this dot represents the principle of commitment to international human rights. And outside of this dot, I would draw a first circle. And this is a small circle. And I would say, this is the circle of some achievements. And outside of that circle, I would put another circle. And I would say, this is the circle of opportunities to advance to a better situation. And beyond that, I said, this huge circle of injustice in the world. So now, my answer again is, we have to strive for this culture of rights and a culture of justice and try to expand outwards the circle of achievements. Thank you.
Thank you, Dr. Bertrand. Now I have a question for Dr. Helene, if I may. Since you have expertise in issues related to sexual violence, human conflict, and so on, I wonder, is perhaps needed when it comes to the education about human rights and justice in general to have perhaps a more victims perspective, so to really see the impact of what we're talking about and to perhaps demystify treaties and conventions and so on, to have a human face to what we're teaching.
Yeah, exactly. And thank you for the question, because I was precisely about to jump on what Dr. Ramcharan said. When we talk about culture of human rights or culture of justice, it's not something from up to bottom. It's not, the justice, and sometimes that was a criticism vis-a-vis the ICC or other international institutions, to have this very up-bottom approach to victims' rights and to victims' perspective and so on. So when we talk about culture of human rights, when we talk about culture of justice, it's again, it's not a theoretical thing. It's about empowerment of victims, and these institutions only exist for victims, and to have this victim-centric perspective, and to be aware that as human beings, we have rights, we have the possibility to have access to different national, domestic, and international institutions. And it's very important to precisely give a space for victims. And as the ICC president said, one of the improvements of the ICC is precisely in the international criminal justice to have this space for victim, and it's extremely a very positive step in the ICC practice, for instance, to have this third-party intervention representing also in terms of remedies, for instance, what the victims have in mind, what kind of remedies they want, because sometimes you have these stereotypes that victim only wants money, but of course it's absolutely not the truth, and sometimes victim only wants to have the recognition of the violation and the harm they have suffered. So yeah, I mean, this international criminal justice centered on victims, it's one of the major achievements, I would say, in the evolution of the ICC.
Thank you, Dr. Helen. And Dr. Conrad, the last question goes for you. Some people think, not only when it comes to justice and human rights, but literally in any field, that universities are somehow silos of knowledge and expertise that are somehow divorced from the contextual reality and surrounding circumstances. So what do you think the role of universities should be when it comes to justice and human rights, and especially if you consider the critical role of NGOs and civil society organizations and faith-based groups and social activist movements? So according to your judgment, how can we nurture that relationship with whoever is outside of the campus doors?
Thank you, Omar. I think it is critical to develop collaborations with different universities and share knowledge. And to some extent, this is already happening, actually. For example, ourselves, we are engaging with a plethora of universities. I don't think there's any university, I mean, my colleagues might chip in here, which are actually operating separately. And also, universities are actively engaging communities that surround them. Students are also engaging with communities that surround them. I spoke earlier on about our own project, which involves refugees. And that is a very important area for our students, because they can begin to understand conflict if they have not actually understood conflict, and see the consequences of conflict. So I would say the interaction between universities and other academic institutions is actually going on right now. And universities are now actively engaging with communities that surround them and beyond. We have launched a course called Remembering Srebrenica online. You may be familiar with it, where we are actually opening up the course for people who want to participate. So universities are doing it. That's what I would say.
Thank you very much, Dr. Conrad. And with that, in the interest of time, due to the constraints of time, sadly, we have to wrap up this session. It was certainly a privilege to hear directly from Jod Hofmansky, President of the International Criminal Court, and also from our esteemed panelists, Professor Hamilton, Dr. Ramcharan, Dr. Kanade, Dr. Tegudja, and Dr. Niambutata from all around the world about this critical issue of Goal 16 within the framework of the 2030 Agenda for Sustainable Development and its connections with both human rights and international justice. Just as a reminder to our attendees, we will indeed upload the recording of this session to our YouTube channel, and we will also share that link in addition to a link to a survey for you to tell us your feedback about this session. And with that, I would like to give the floor to Mr. Robert Skinner, who is the Deputy Director again of the Outreach Division. Rob?
Yeah, thank you, Omar. And I would just like to thank the panelists for such an amazing discussion. I mean, wow. I mean, the broad range and the diversity of perspectives that you brought to this conversation was really, really fascinating, as I expected that it would be. And I'd also like to thank all of the participants that contributed in the chat with the questions and comments. I mean, we truly have a global audience here that was participating in the conversation and asking really important questions about, how can we have justice, through the ICC and otherwise the national court level, given the many constraints that we have around the world. So really fascinating discussion. And I also apologize. I mean, I feel like this conversation could have gone on much longer, given the nature of the questions, given the amazing depth of knowledge of the panelists, and really, really fascinating. So, and just going to the last question, Omar, and thanks for kind of the setup and how universities and institutions of higher learning can engage with communities around these kinds of issues. Just to note that that's really what we're trying to do at UN Academic Impact, bring the universities closer to the communities to develop solutions and drive answers to these really, really thorny problems that we're all trying to address and tackle. And I think that, again, to all the panelists, you really were direct in addressing all these issues, and very appreciative of, the way that you got through the initial comments that you had, so that we were able to have time to have a dialogue and conversation. And Omar, Omar from our team, I would really like to thank you for your really masterful moderation of this conversation and keeping things going. You really did an amazing job. So thank you to you all. We look forward to the next UN Academic Impact sessions, and again, look for the on YouTube for this this conversation, as well as the email. Again, I just very, very appreciative of all of you for taking the time and producing such a great conversation.
Thank you very much. Thank you all. Bye-bye.